All right, the next case on the docket is Prestige Home Centers versus WANDA PRESTON. Would you like time for rebuttal?
Yes, Judge. 5 minutes, please. And I'd like to, may it please the Court, I'd like to start out by saying that my name is Anthony Lanassa and not Burke Lopez, as is probably indicated on your calendars. By way of a quick review, Prestige is in the business of selling and manufacturing.
Let me ask this. What authority would the arbitrators have to modify the terms of the arbitration agreement, the contract?
To modify the contract? Well, I don't believe that the arbitrators necessarily by themselves would have that authority, but I believe that authority would be that the sales contract itself, the 1998 sales contract, could be modified by the parties, which is exactly what happened and is reflected by that scheduling order.
And so you're suggesting that the scheduling order was one, reflected some sort of meeting of the minds, and my question to you is, how can a scheduling order, which neither party in this case was involved in drafting or negotiating, constitute any kind of meeting of the minds?
Well, I believe that the scheduling order itself was issued by the lead arbitrator after a phone conference where counsel for both parties was present, as well as two of the arbitrators, and that in this phone conference, counsel at the time for Prestige indicated that Prestige would like to reserve any amount of attorney's fees awarded, if any, to the discretion of the trial court judge. And this, if we look at the actual contract between the parties, it does allow that the sales contract may be modified by a subsequent written agreement, and that's what we...
So is that scheduling order signed by the parties?
It was not signed, Your Honor.
Okay. How is that a modification of the contract?
Well, because we believe that the contract...
And I guess the further question is, even if there's an argument that it is a modification of the contract, that was presented to the arbitrator decided that the contract controlled over the scheduling order under well-established case law that defers to the decision of the arbitrator. I don't even know how you could argue to the trial court that that decision should be overturned, and the trial court disagreed, and now you're here. I'm having a hard time seeing why we're here, actually, on this case.
Yes, Your Honor, and we don't... we certainly are not going to argue the case law that confers a substantial weight to an arbitration finding. However, the contract itself specifically states that the agreement may be modified by a subsequent written agreement. It doesn't state that it has to be signed by both parties. It also, and that's what we agree that that's what we argue, that the scheduling order is such a subsequent written agreement, and pursuant to Florida statutes 682.13 and 682.14, an arbitration award can be either vacated or modified to correct an error if, as we believe in this case, the arbitration panel decided an issue that was not properly presented to them, which is exactly what we believe the case here is. And so that's kind of how we get to this point, Your Honor. So essentially that is the crux of the matter on appeal. Did the arbitration panel specifically have the authority or did it exceed its powers in awarding? And we would submit that the plain language of the scheduling order should control and point out that at no time during the phone conference did counsel for Preston object to that term being added to the scheduling order, and then at no time thereafter did counsel for Preston object up through the arbitration. In addition, we're here for a couple other counts on appeal, and we do cite basic contract law in our brief. I don't know if you want me to go into that or not regarding the points of a subsequent contract abrogating and one earlier in time. But the other points on appeal are, first of all, we appeal the final judgment that was entered into October 11, 2007 by the trial court, which we believe contained amounts in that award which were not properly, which should not have been included in that judgment.
Is that just an issue of timing? You're arguing that just because it had been paid at the time of the final judgment, but the arbitrators had awarded it, that it shouldn't have been included in the final judgment?
Yes, Your Honor, yes. One of those amounts we believe should not have been awarded by the arbitration panel, that being the 21st century mortgage amount, but the other amount, which is the $47,000 in personal property damages, we believe. But
the trial court found that that wasn't reasonable evidence to rely on because it was basically hearsay.
Yes, Your Honor, I believe that the trial court did find that as far as the 21st century mortgage, but prior to the judgment being entered, there was a partial satisfaction which had been entered into by appellee, which should have laid that issue to rest and let it not be included in the final judgment, either of those amounts. In the case of the mortgage,
I'm trying to understand what the harm is. Couldn't you do it either way? I mean, I guess normally the trial court's responsibility is to simply confirm the arbitration award in a judgment, and then, which is what happened here, and then you could do a satisfaction or partial satisfaction of judgment and have that file to indicate that it was paid. I mean, that would get you to the same place, official confirmation of the fact that the amount was paid and not owed. Why is it wrong to do it the way the trial court did it rather than the unusual way to do it, I would think, which is to have an evidentiary hearing or some kind of hearing to amend the amount of the arbitration award to reflect something different in the final judgment? That seems sort of unusual. Why not just
well, Your Honor,
the way it was done?
I'm sorry.
Go ahead.
The partial satisfaction, the trial court had that when it made the final judgment, and really it becomes an issue just because of the whole prevailing party determination pursuant to the contract. The contract states that the prevailing party, if using these facts, if Preston was to be considered the prevailing party, she would need to obtain a judgment greater than the last good faith written offer, and that's kind of how this comes into play. The last good faith written offer was $90,000. The arbitration.
We understand the significance of it.
Yes, and so that's. And I'm not sure if I addressed your questions directly then.
That's fine.
That's fine. So and as I stated before, I'm not here to argue that arbitration awards aren't given a high degree of conclusiveness. In fact, that's undisputed. Obviously, we simply are arguing that, first of all, the arbitration panel overstepped and exceeded its authority in awarding an amount of attorney's fees that, pursuant to the scheduling order, its own scheduling order, should have been left up to the trial court, and also that the determination of the prevailing party was incorrect by the arbitration panel. In the interest of not taking up any more of the court's time, I would reserve for rebuttal.
Thank you.
Thank you.
Good morning. May it please the court. My name is Hans Kennan. I'm here on behalf of the appellee, WANDA Preston. The appellant is complaining that the arbitration panel followed the specific written mandates of the contract that it drafted. That's why we're here today. They're unhappy with that result. This court, in the Chandra case, 727 Southern 2nd 372, said arbitration is supposed to be an alternative to the court system, not something that would lead us to this here today. They attempted 3 different times. This is actually a 4th bite at the apple for the appellant. Arbitration panel said, Ms. Preston, you prevailed. We're awarding fees and costs. They went to the trial court. The trial court confirmed it. They objected to that. They lost. They filed a motion to then vacate. They lost. And again, this brings us here kind of on the fourth attempt today to reverse what Florida case law says is a conclusive process. We're supposed to do that to avoid ever having to come here. Also in Schumacher, which is a Supreme Court case, Florida Supreme Court at 542 Southern 2nd, 1327, held an arbitration award cannot be set aside for mere errors of fact or law. Even assuming the scheduling order was correct in that it was supposed to have some effect, the fact that the arbitration panel then reviewed the contract and determined that they were required, the contract says shall. Since they're required to do so, they simply said, well, whatever we put in this more ministerial order wasn't correct, because now that we've seen the contract requires us to assess those attorneys' fees and costs. Also, the arbitration award is not something that's on
the appellant argues that there had been a telephonic conference and that it had been modified, and the contract did allow for did allow for modifications, correct? Yes, sir. Go ahead.
I was going to say is, even assuming that there was an agreement to allow the circuit court to determine fees and costs in this case, the appellant, Prestige, made the issue of fees and costs into an issue that had to be submitted to the arbitration panel. The issue under 682.13 and 682.14 deals with whether there's been an exceeding of powers or if they addressed an issue not submitted to them. In this case, 5 days before arbitration, Prestige made an offer of $90,000. That offer was inclusive of attorney's fees and costs. Under the prevailing case law in Florida, I cited to the 4th DCA opinion in Holiday Rambler, if you're going to include attorney's fees and costs in an offer where the contract allows for an award of fees and costs, the panel, whoever it may be, whether it's court or arbitration, has to determine those fees and costs and add them to the amount of the underlying award to determine who is the prevailing party. So the fact that Prestige made an offer inclusive forced the issue of who prevailed, and in fact, the determination of fees and costs were necessary to determine, in fact, who prevailed by trying to set it.
My question went to the argument that there had been a modification of the contract.
Yes, sir. And I'm saying,
and do you dispute that?
I don't think it's a modification of the contract. I think a bunch of lawyers talking to an arbitrator trying to figure out how they're going to handle the trial is always susceptible to a change either by the court or by the arbitration panel. So I don't think that's a modification. I don't think that's, under the contract law, a modification of a written contract when, as Judge Lawson pointed out, nobody signed it. It was simply a discussion between lawyers saying, how do you want to handle this thing as we go forward? So I think that's always subject to review, to challenge by the judge or the panel or by the parties themselves. In this case, the detailed written order by the arbitration panel said, hey, we know what we said before, but once we've reviewed this contract, we have a requirement to do so. And it goes back to my other argument that even assuming there was a modification, the fact that Prestige said, no, we're the prevailing party now by satisfying this mortgage in the middle of it, required the arbitration panel to determine those attorney's fees and costs to even be able to make the determination as to who was the prevailing party. In this case, the issue was the 21st Century Mortgage Agreement. I think it's just a strategic move. I think that was all Mr. Lopez had available to him. He said, well, if I bring in a document, a hearsay document, a fax document, and say, look, we've satisfied this mortgage, so you know what? She only has half the damages now. We would have to be the prevailing party. It would still require the assessment of attorney's fees and costs because of the wording of the appellant's contract. One reason I think the court found, I think Judge Hudson pointed it out, was that this fax document was supposed to relieve Ms. Preston of her mortgage agreement. Now, 21st Century Mortgage is a third party, not present, and my client is supposed to accept a faxed letter and say, okay, don't bother putting it into the award appraisal panel because I have this faxed letter. She gets sued next year by the mortgage company, and the cold comfort she has is a faxed document when she tries to plead release. The arbitration panel, we believe, properly found that this 11th hour or mid-hearing attempt to wrest us from being the prevailing party, someone who was unsuccessful legally, factually, and from an evidentiary perspective.
Why did you have your client execute the satisfaction of judgment for the satisfaction of the personal property?
Well, we actually, between the time the award was entered and when the judgment or the confirmation of the appraisal award was entered, they did make payment of the personal property, and obviously there was this document that discussed the satisfaction of the mortgage. However, what the trial court found was that since it wasn't paid prior to the award, it needed to be included in the judgment in the event that something hadn't been paid. So the concern was we wanted a judgment that fully comported with all of the arbitration panel's findings. We actually executed the satisfactions contemporaneously with the entry of the judgment confirming the appraisal award, simply to take away an argument and to make it simpler for the court and for Prestige to know that we were not attempting to get money and then try to then assert that judgment again. We provided it hopefully to make things more streamlined than anything else. The appellant's disappointment with the award or with the attorney's fees award or anything is not a basis for relief in this court. As the court said in Schurmacher, the award operates as a final and conclusive judgment, and however disappointing it may be, and clearly there's disappointment on the part of Prestige, the parties must abide by it. The 50CA has said that, the Florida Supreme Court has said that. This is really not an issue for us to be here today at all, in all honesty. This could have been decided either on the paper or simply never been brought. Obviously, the right to do so, and that brings us here today. I believe the rest of the brief speaks for where we are today. If the court have any further questions of me, I'm happy to address them.
Thank you.
Thank you.
Thank you.
Just very briefly, just like to address one or 2 points. First of all, counsel states that Prestige brought the issue of attorney's fees into the arbitration determination by with its contract, but I would state that the contract does not state that the attorney's fee amount is to be determined in order to determine the prevailing party, and that amount is the attorney's fee amount is only awardable after a prevailing party is determined and not before. I think that's kind of putting the cart ahead of the horse in that regard. And also regarding the scheduling order, I just want to point out that counsel was present on the phone conference and that counsel could have objected at any point in time, I think in 6 weeks leading up to the arbitration. And unless there are any questions.
Thank you.
Thank you.